Well, you know that this is a seminar, or this is a series of seminars that are dealing with Regulation 2019-1111, which I don't know yet how I should call it, if it's Brussels IIter, the new Brussels II, or how we will in the end agree to call it. This is a regulation that is meant to replace the present Brussels II bis regulation, and that will become applicable on the 1st of August 2022, as established in Article 105. According to the transitional provisions, it will only apply to legal proceedings instituted, authentic instruments formally drawn up or registered, and agreements registered on or after the 1st of August 2022, which seems a long time away. We hope that it will be after COVID, of course. It will be the new period, the new when we are back to normality, hopefully. So it seems still far away, but it is time to prepare, we think. And that is why we wanted to have an expert seminar. And also it is time to evaluate what has been achieved. The thing is that there will be 6 webinars. Instead of having a one-day conference or a two-day conference as we planned originally, because online activities are more tiresome, we decided to split it up and to have small or shorter webinars that can also be attended to individually. 5 of these webinars focus on more specific topics like enforcement, child abduction, cooperation of authorities, and so on. You have seen the program. This first webinar bears the title New Challenges. And of course, this is a title that is very open and that can be interpreted in many ways. However, I think that it can be understood as an invitation to reflect more broadly on the added value of the regulation. This is not where we will go into the details of one thing or the other, but we want to ask ourselves the question, what does it bring? And I personally decided, my respondents might have done otherwise, but I personally decided to focus more on what has been achieved and not so much on what is missing or what could have been done. Why? Because I think it is a bit unfair of us academics. We sit in our rooms and we are always telling people what they should have done and what they didn't do. Of course, the constraints under which this regulation was negotiated were very important, and there are some achievements, there are some positive issues to be highlighted. I will start out immediately by saying that it is, in my view, a conservative reform. So there are not so many groundbreaking changes, but there are very many changes in detail, some of which incorporate the case law of the European Court of Justice, some of which are a response to requests from judicial authorities and legal professionals. And if I look at it, my first impression, of course, is that it is a very long regulation. It has 105 articles, a preamble with 98 recitals, and here I have to say, here I will criticize. In my view, we have to think about what we are doing with the preambles, because it is really, you know, if you have to read all the preambles, it becomes very difficult. And The value of these preambles is, of course, also something that is unclear. And then there are 10 annexes. The last one is the one that tells you the changes that have been made to the numbering of the articles. Of course, any changes in the numbers of the articles are very annoying, because now that you know that article so and so says something, the number changes, and it is a bit of a nuisance. So my first impression is, of course, that there is a lot to absorb, and for practicing lawyers, particularly for those that are not only practicing international family law, but that are dealing with family law in general, which are most of the practicing lawyers, it is quite a bit to come to terms with this regulation. And this is always something that needs to be considered, because reforming legislation has also costs. And the costs are that all people have to learn what is new and what is not new. However, I decided that I wanted to stay positive, and in the end, I decided to focus on the main innovations. And I have made a ranking of these main innovations, and I have tried to look at what is really new. What I think is really new, and of course there is room for disagreement, and I also decided to make a ranking starting on what I think is the most important change and going the ladder down. I have to admit that some of these changes might not be immediately relevant as a fundamental practical change. However, they open new avenues, they open new possibilities. And we know that Europe is built step by step. And some of these apparently timid changes are, in my view, have a big potential. Number one is a new approach towards public documents and agreements. And this new approach towards public documents and agreements is highlighted in paragraph recital 70 of the preamble, that states that authentic instruments and agreements should be treated as equivalent to decisions. I think that from a private international law perspective, this is an important innovation. We have been struggling for some time with how to achieve continuity to legal situations that have been created abroad. How should we try, on the one hand, to give continuity, but at the same time guarantee that private international law rules have not been circumvented? And here, a certain way has been found, because this treatment of public documents and agreements as decisions is connected to a system in which we have certificate, and this certificate is made conditional upon the jurisdiction rules of chapter 3, having been complied with. I also think that it is important that agreements are particularly dealt with, it is, of course, a modern trend in family law that we are telling people that they should reach an agreement, that it is better for families if they reach agreements and they solve their disputes through agreements, and there are still some problems with the portability of these agreements. And in this sense, I think that this is an interesting issue. The next issue that I would like to highlight as an important step forward is that we have a section dealing with common provisions on enforcement. So this regulation tries to bring about some harmonization of the enforcement rules, which means that we are no longer in the realm of private international law, but in procedural law. This is also important, an important step, because after the abolition of exequatur, even before it was achieved, I think that there was already some awareness that the real problem was not so much exequatur, but enforcement, because there are different levels of efficiency in the enforcement machinery of different member states. There are member states that are quite good at enforcing, and there are other member states that have very many difficulties in enforcement, and this is something that is ultimately very important for citizens, because citizens do not understand why you cannot tell them, well, this is no longer an issue that belongs to private international law, so you have to live with the fact that your judgment cannot be enforced. It is a bit ironic that the content of the chapter is not so very, it's a bit thin, and that there is a common ground for non-enforcement, for suspension of enforcement. But still, it is, in my view, an important step forward that should be recognized. Third, in the ranking, mediation in child abduction. We have an article in the regulation, and I saw that Laura Carpaneto was so nice that she put the regulation in the chat, so it is easy for you to download it if you don't have it. There is an article in the child abduction section. It's a new chapter that is dealing with child abduction, where it is stated that the court shall invite parties to consider sorting out their difficulties through mediation or alternative methods of dispute resolution. So this is going beyond what we had before, where, well, there was in the Hague Convention this idea that we should strive to solve our issues voluntarily. Here, mediation needs to be considered seriously in all cases, except in a few ones, except when it is contrary to the best interests of the child, or where it will unduly delay proceedings and so on. I think that this is an important issue, and it is an issue. It is an issue that can be interpreted as a recognition that the whole child abduction system needs to be rewired. What do I want to say with this? I want to say with this that, of course, we are not questioning that abducted children should be returned. Abducted children should be returned, of course, but that is not enough. We need to help people to sort out their problem, preferably between themselves. And this is a matter that has not been approached, but that I think would be also important, for the future, we need to focus also on lawful relocation, not only on wrongful change of residence, but also on lawful change of residence. When should it be permissible to relocate? And if I'm saying that the system needs to be rewired, this shouldn't be interpreted as something that is negative or that is a taboo or that endangers any of the achievements of the abduction system. This was number 3 in the ranking. Let me proceed and have a look also at time. Another important provision that brings something that is really not new is that we have a provision in Article 10 reinforcing party autonomy in jurisdiction. We had a possibility of choice of court under Article 12. It was connected to matrimonial proceedings, to proceedings on legal separation, divorce, and annulment. Paragraph 3 of Article 12 also allowed for prorogation in connection to other matters. It was interpreted by the Court of Justice as not requiring any pending proceedings. And now this is made absolutely clear, and Article 10 actually even provides for agreements that are made before there is any contentious matter. And I think that Article 10, but perhaps this is going too much into detail, has tried to strike a balance between party autonomy and not binding people to decisions made by their former selves. What do I want to say with this? Well, the agreement is not binding for the courts, because the courts can set aside the prorogation agreement if they think that it is not compatible with the best interest of the child. Number 5, direct judicial cooperation and communication. We have in Article 86 a provision that actually very clearly states that courts can communicate and cooperate directly, and it is placed under the general provisions. So it is not tied to any particular circumstance or any particular subject matter. There is a list of situations of provisions in which this direct judicial communication would be particularly welcome, but it is open. So direct judicial communications are there, and it is an important issue because it means that there can be a cooperative administration of justice in these international family law matters. Finally, and I think that I'm starting to speak too long, the hearing of the child. Many might be disappointed by what has been achieved. There were more ambitious proposals. However, in the end, there is something that is important there, I think, which is that Article 21 establishes that different methods of hearing children are equivalent. And in my view, legal transplants, I mean, taking one thing from one system and transplanting it into another system is sometimes dangerous because the soil is different, the circumstances are different. So recognition that there might be different methods of hearing children, and that one method works in one jurisdiction and the other works in the other jurisdiction is an important